right, the court is calling 2023 CR 3848, State of Texas versus Michaela Elise Johnson. Can I have parties announced for the record for the state? Defense?
Patrick Hancock for the defendant.
All right, and are you Ms. Johnson?
Yes, ma'am.
All right, we're here for sentencing. You entered a plea of no contest to robbery on December 4th. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposing your application for community supervision or deferred adjudication. They're taking certain items into consideration. All right. Did you all have a chance to review the PSI report, state?
Yes, Judge.
Defense?
I did, Your Honor.
Any objections to the PSI report, state?
No,
Defense?
no, ma'am.
All right. State, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin, Michaela's mom.
All right, Ms. Franklin, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you can
Okay.
state your name for the record.
Alicia Franklin.
All right, defense.
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are aware that Michaela has accepted responsibility for a robbery here in Brick County.
Correct.
And today is the day that the judge can either send her to prison or entertain her application for probation or deferred adjudication.
Correct.
Ms. Franklin, let me just ask you, how old is Michaela?
As of now, she is 18. When the case started, she was 17.
And when did she turn 18?
November 3rd.
And where is she a student at?
At Roosevelt High School.
What grade is she in?
She's a senior.
And being in Roosevelt High School, has she made future plans, applied to any universities, or done anything at this point in her senior year?
Yes, she was accepted to UTSA and we're pending.
Excuse me, please whisper.
Say it again, ma'am.
She was accepted to UTSA and we're pending the application for Clark Atlanta University.
Very good. And how is she doing in school?
She's doing good. She's on my honor roll. Right now she has all A's and perfect attendance since she's been out.
And did Michaela request a letter from one of her school counselors to offer to the court today?
She did.
John, I tendered this to the state for their review. At some point, you'd like me to look at that, Judge.
All right, any objections to the court reviewing this? All right, you may continue.
Ms. Franklin, with regard to that letter, is it a positive review of how Michaela's doing at Roosevelt High School right now?
It is. Michaela's right now, since her release, she's at the best she's ever been. She's focused, she's serious about furthering her future for college, and she's on the right path.
I'd like to take you back to, I guess, the time around this offense. And before I do that, I want to ask you, are you a single mom?
I am.
Does Michaela have a father in her life who's active, or?
He's not active, not consistently.
And does she have any siblings?
She does. She has a brother and a sister from her father.
But living in your household is just
No,
you?
no one, just me and Michaela.
I want to take you back to around the time of the offense. Do you remember getting a call that Michaela had been locked up for some very serious offenses?
Yes, I do.
And can you tell the court what your response was?
That she needed to sit there. I left her in there. She needed to understand what she had done and take responsibility. I left her in there for 5 months before I bonded her out, so she could understand that she didn't do anything, it wasn't something small. She needed to understand exactly what she did and what she could look forward to. She needed to know what prison or their county was, what jail was.
And do you think those 5 months had a significant impact in her life?
Most definitely. I know for a fact she doesn't want to go back. She definitely has a true meaning of what jail is.
And was that your goal at that time?
That's definitely was my goal, because I could have bonded her out the same day or the next day. I mean, I could have got the financial means to get her out. So it was definitely my goal for her to learn her lesson, and hopefully we don't ever have to revisit this again, which I don't think we will. I honestly think that she did learn her lesson.
Miss Franklin, let me ask you, at the time when she was arrested, were there some behavioral problems
There-
that you picked up on?
Yeah, there was, but I thought she was just being a rebellious teenager. I didn't realize she was like depressed and had low self-esteem until she had suicidal thoughts. I took her to Little Ridge, but you know, they let her out and she did a little counseling here and there. So I thought she was just being more rebellious to herself. I honestly didn't know it was mental health issues there. But once I did know, I've gotten her help.
What mental health issues have you discovered regarding Michaela?
Definitely depression, low self-esteem. We've been going through exercises with the counseling sessions. And me, myself, just trying to boost her up and get her on the right path to feel good about herself.
And do you think you're on a positive path right now?
Most definitely we are.
She's back living at home.
She lives at home. Our relationship is really good. She's more open. We actually have conversations about how she's feeling, and I think we're on a really good path.
And that's different than what it was before the.
Most definitely, she would stay to herself more, so lock herself up in her room. You know, just for me, what I thought was normal teenage stuff, but evidently it was a little deeper than that.
Ms. Franklin, you own the business. Would you tell the judge what you do for a living?
I do. I'm Sergio Lamir salon, a hair salon in San Antonio.
And have you and Michaela talked about her interest in working in the salon?
Yes, but actually before this, she did. She was my assistant, and to be honest, I need her back as an assistant. But she wants to be a barber, and to get her through college, it'll be something for her to fall back on. And I can. I'm also an instructor, so she can get some of her hours through me.
You mentioned that she's been accepted to UTSA.
Yes, she's been accepted to UTSA, but she's also, we're pending the application for Clark Atlanta, which she preferably would want to go.
And what would be her interest in studying in college?
Business marketing.
So you left her in jail for 5 months, and now she's been on pre-trial release as a condition of her bond.
Correct.
I know we had one GPS circumstance that we had to take up with the court, but
Yes.
other than that issue that was straightened out here in the courtroom, do you think she's been compliant with all the rules?
Yes, she's been compliant, and I also make sure she's compliant. I mean, we get home on time, way before time. We don't take no shortcuts. So yeah, she's definitely compliant.
I know that today we had the opportunity, the three of us, you, me, and Michaela, to go through the pre-sentence report. You can see there are some pretty raw feelings on the part of the listed complainant.
Yes.
Can you tell me if you think, even before today, do you think Michaela recognizes just how serious this offense was, and the fear that people were placed in, and the after effects of that fear?
Yes, she definitely recognizes that. She's definitely voiced how remorseful she is for this. I know for Christmas we did, she wasn't able to actually go to the battered women's shelter, but she did produce a toy drive. So where she marketed it, and we received a lot of toys, I think over 500, and took it back to the battered women's shelter. She definitely is remorseful, and she definitely understands that she put these people in fear, and it's not to be taken lightly.
Very good. Could you address very quickly whether you think your daughter would be a good candidate for probation or deferred adjudication in this court?
I think she would be a great candidate. I think, matter of fact, I know she has a bright future. This was something that she got herself into that I know she regrets. And I don't think that she should be sent to jail. She's done 5 months, and I understand that it's not the same as 10 years, but she definitely recognizes and has had a taste of what jail is, to not do this again and not be in any more trouble, and to succeed and hopefully help other juveniles and help other people who are going in that direction.
Ma'am, that's all the questions I have. The state
Okay.
has an opportunity to ask any questions they want.
Yes,
Any questions?
Were you aware that this offense occurred on February 8th of 2023?
once I got a call from the Michaela when she was already in custody,
So you knew the date.
yes,
And what day was that of the week? Do you remember?
I do not.
Would it surprise you that it was Wednesday?
I mean, I don't know. It is a-
It was a Wednesday.
Yeah,
Would it surprise you that this offense occurred shortly before 1 p.m.?
the whole thing surprised me.
But I'm asking specifically about the time at which the offense occurred. Would that surprise you? Did you know that it happened?
I did know. I mean, I've known since by reading the papers, and
Where should Michaela have been?
she should have been at school.
So do you know, or did Michaela ever talk to you about what happened during this offense?
Yes,
So you were aware that the victims in this case was a mother and her young 4-year-old son,
yes, sir.
and you had a chance to read the victim impact statement.
Yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir. I definitely understand the turpitude of the case.
So you understand what the victim's feeling when she's saying that prison would be appropriate here.
I don't think it would be appropriate for Michaela
And ma'am,
for the simple fact.
I'm gonna ask if you could answer my question. Would it surprise you or does it shock you that the victim in this case is asking for prison?
No, sir.
Is it understandable?
It definitely is understandable.
And were you aware that the other two people that participated in this act, that they were both younger than you?
Yeah,
So she was the oldest one out of the group, right?
okay, yes.
So she should have been able to make better decisions than the other two, correct?
I don't agree with that. The other two had been in trouble, I understand, and she also was the only girl. So,
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in the victim and her son?
I understand that she was the driver, yes, sir.
Specifically that boxed in the victim and
I
her son?
understand.
Nothing else to say.
All right, any other questions?
Ms. Franklin, I think I tendered it to the judge as a part of the other letter, but we did take Michaela to be evaluated by Mark Harris.
I did,
He's a licensed therapist, is that correct?
yes.
Judge, if I didn't give you that.
Yes, you did, and I reviewed it.
Okay.
It's
very good.
attached to that.
Thank you, Judge. And you had the opportunity to look at his assessment, and that's helped you on a path of understanding her now, is that correct?
Yes, it did.
All right. Thank you.
Thank you for coming in. All right, defense, call your next witness.
Judge, that's it.
All right, did your client wish to say anything?
Judge, I think I'm going to speak for her.
All right, so I want to let the parties know that part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure. That was
But
me.
then she comes back and she does make a comment. And it says the defendant later stated, I feel it needs to be looked into more rather than what they are saying.
And I think we addressed that actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of a process of explaining that to her. So I think that she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that contrary to what the state wants to put forward, is that she was not the leader of this. She was a follower in this, and she did not possess or hold a gun. So I think as to Miss Ballard's point in the PSI, maybe she could have gotten out of the car and said, hey, don't do that. She didn't do it. But the point of the matter is that she was in the car and not actively terrorizing these people. I make that distinction, but I also understand that if she's there, that she's a part of it.
All right, because I'm reading the PSI. I'm sorry, reading the stipulations. And the stipulations, it says that she was the one who boxed the driver in.
Well, Judge, we're here taking responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right, anything else from the state?
Your Honor, I was informed by our victim advocates that the witness on Zoom was dressed, it was a brown sweater, that's what she's saying that she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge, I just wanted to make sure.
All right, thank you. All right.
I don't want to overstep, but I do want to make a brief argument next time.
Yes, you may proceed.
So, Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions, how quickly can we get out of jail? I think Ms. Franklin took a very brave approach for a single mom, and that is that I want her to sit there. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by, and so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from the Roosevelt High School from Ms. Howard says she's really doing well in school. It's hard for me to believe she's 17 years old when I met her and charged with such a serious crime, and she's turned 18 and she's only 3 months into her 18th year. So Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this, because we've spent hours talking about the what ifs and how you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Mark Harris, and Mr. Harris is very good through the juvenile probation and through private practice of bringing these young people in. He specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg this court to give this young woman a chance. A conviction and being sent to prison is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path, and we'd like for her to stay there with the court's permission.
State.
Judge, the situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, But in that moment, she could have made different choices. Choices is what she's gonna have to make going forward. It's something that the state feels that prison would be appropriate here, the victims feel that prison would be appropriate here. That's what we're asking for.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think have the more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation,
Mhm.
and then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there will be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second-degree felony is quite a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here, it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring the court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the Barrett County Jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that will sway the court in giving her a chance at a future without being another young Black female with a conviction on her.
Here's the court's problem. And what I think people need to look at. Sometimes punishment, and all attorneys will tell you when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the
Judge,
court.
isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So and I'm not trying to argue with the court, but under that circumstance, then no one should be eligible for deferred adjudication.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is Father Andrew, I've seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing them in. She says that she had never had or handled a gun that night. When the police lit up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is.
Well, I don't think it's her feeling. So it's not going to be in a police report.
Right,
but I can tell you that was her feeling on this. She did feel threatened by these 2 young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's our answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
No, Your Honor.
No, you're not.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
All right. All right, this is a PSI, correct?
Yes, Your Honor.
All right, court is calling 2023 CR 5231, State of Texas versus Gilbert, Pruitt. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Laura Meadows for defendant.
Are you Gilbert Pruitt?
Yes, ma'am.
You entered a plea on December 4th of no contest. According to the plea bargain agreement, the punishment is to be assessed at a cap of 10 years, and the prison in the state is opposing your application. Have both parties had a chance to review the PSI report?
Yeah, I have. Yes, Your Honor.
Any objections to the PSI report?
No, Your Honor. No objection.
All right. State, do you have any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes.
All right, who would you call?
Gilbert Pruitt.
All right, Mr. Pruitt, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Gilbert Pruitt.
All right, defense?
Mr. Pruitt, you have applied for probation in this case, correct? Yes, sir. Why do you think you'll be a good candidate for probation?
Well, my time here at Bear County this time around, I mean, I'm 42 years old, and it's really getting childish now, you know. I have to
Mhm.
grow up and be responsible, and you know, I'm a granddad now, so I gotta lead by example. I should have done this a long time ago, but you know, I gotta start somewhere, you know, and since I've been incarcerated, this year here showed me a lot that I know I can do it, but with help. You know, I've always tried to do it on myself, and obviously it don't turn out right, you know.
Have you, talking about the help, what help do you need, do you believe?
Well, I believe, really any kind of help that help me out, you know.
Have you ever had substance abuse treatment in a facility?
Uh,
Okay. Have you had any mental health?
I was when I was on parole at the Center for Healthcare Services, but that was it. That once I finished parole, I couldn't go back, and I didn't exceed help after that. I tried to do it on my own.
So do you think treatment, both substance abuse and mental health treatment, would help you?
Oh, I believe it.
Would you be an active participant in those treatment programs?
I sure will. Yes, sir.
Now, you have given me quite a few certificates that you've earned at the jail. Can you tell the judge which courses you completed and what you learned in those courses?
Yes, sir. My first certificate would be traumatic stress and resilience 1 and 2. That course there, I graduated that course. It's to all the traumatic events that I've had or people have had, but it's really to like ourselves, you know, because we all have different traumatic experiences.
Mhm.
And I've learned that, you know, it don't hurt to ask for help when you're in a situation. A second certificate that I achieved is I believe with the maintenance program.
Mhm.
I graduated that, and I was top of my class, and so now and it's good to say, you know, since I graduated that class, that I have Captain Motain, which is a captain in the jail. I'm his trustee there, and I help him in his South Tower area. Um, you know, paint and do the flooring, the tile on the 5th floor. And I help the instructor with the new guys that get nominated to be in that class. I help guide them in learning the tools and everything that's needed. And then I'm in GD class. I graduated art class, and so the teacher there, Miss Bozick, she got it approved to where it was me and some other guy, but the other guy, I don't know where that guy's at now. But the chief approved her to do murals and inspirational quotes
Mhm.
in the jailhouse. And that's up in the air right now until further notice. But I've accomplished a lot, you know, this year that I've been locked up, and it's really rising me up. Like, no, I know I can do it, but with help, it'll be that much better.
Okay.
Now, if you were to be released on probation at some point, do you have any outlook for a job, for employment?
Yes, sir. Matter of fact, I have my sister, Arabella, and she and her husband have a business in remodeling and leveling houses. And there's also I have a flyer that they say once you get out, I can give them a call, and that they'll pay for my schooling and give me like $15 an hour or something like that. And so I really want to go back to school and be a septic engineer, you know, because I mean, it's a dirty job, but
Somebody has to do it. Yeah.
you know, so I'm looking into that, you know, and it can be done, you know. I know I can do it.
And in fact, your sister is here in the courtroom just before you, right?
Oh, yes, sir. She's in the back with my mother and here.
So to reiterate, please tell the judge why you will be successful in probation.
Well, because I have obviously my family that loves me, you know, and they're tired of this evolving door, you know, and it's heartbreaking, like me as the elder, you know, and I'm the only son that I've been going through all this turmoil, but I'm glad that I realize it now and catch it, you know, and then with their support, you know, to help me do that much better. And sometimes it's good to have that kind of discipline from your loved ones. I never used to like, yeah, whatever, you know, back talk my mother and all that, but all along, as I realized, all she was doing was just direct me in the right way, you know.
Okay, pass the witness.
State.
Good morning, Mr. Pruitt. My name is Hank Wilkins. I'm one of the prosecutors here.
Yes, sir.
If I ask anything that you don't understand, just let me know and I'll rephrase it, okay? In 2001, did you, were you placed on probation for aggravated assault against a public servant?
Yes, sir.
Okay, were you successful?
I wasn't successful on that because, you know, I was young and I was like, what, my young 20s, I believe.
Do you know how long you were on probation before you went into the prison?
No, sir, I don't remember.
But would it be surprising that it was less than a year, less than 6 months? Would that be surprising to you? Okay.
Oh, no.
And it might help Diana if we can. Okay, and so in 2009, did you go to prison for felon in possession of a firearm?
Oh, I sure did, sir.
And let's see, and that was also for possession of a controlled substance, right? And then you did state jail in 2015 for fraudulent use and possession, right?
Yes, sir.
Okay. So can you tell the court, why is this time going to be different? You've had this opportunity on probation before, but that didn't work for you. So why do you think this time's going to be different?
Well, this time it will be different because I'm of age now, and I'm not in the streets as like I used to be. That's where I was at. That's where I called home, and my mother didn't raise me in the streets, but I never had that father figure in my life to I had to figure it out myself. And now that I'm of age, I'm 42, I'm only getting older, and I see a lot of old people just keep coming back and back, and I don't want to be one of those. I have to break this cycle. And so in order to break this cycle, I have to just do what's right. And if I do everything right with help, everything will come out right.
So you got arrested for this offense in March of 2023, right?
Yes, sir.
And stole a car, right?
I didn't steal.
Okay, but was it your car that you were driving?
No.
And when the police tried to pull you over, did you pull over right away?
Yes, sir.
And then once you got out of the car, and ran from them, right? Yes?
Yes.
Okay. And how old were you when that happened?
It was last year.
Last year, okay. So did you go over this cap evaluation with your attorney?
Yes, sir.
Okay. On page 7 here, this paragraph, I guess to me, it sounds like you're not really taking responsibility for your actions. Or you feel like you're taking responsibility for your actions?
I have to take responsibility for my actions.
No more questions, Your Honor.
All right, any further questions?
No further questions.
Any further witnesses?
No further witnesses. Just talking.
All right. So, Mr. Pruitt,
So
what I can tell you is I read the PSI report and I understand what you're saying, and I've internalized what you're saying. And I know that people get to a point in their life where they're just tired, right? Tired of going to prison, tired of this lifestyle. But the problem is you're habitual. Your criminal history is not good. And, because of that and because of other things that I've heard and that I've looked at in the stipulations in the PSI, I'm not going to grant your application. So I'm going to find you guilty. I'm going to ask that you be placed in the therapeutic community, the mental health community at the prison. I'm going to sentence you to 5 years in the prison, give you credit for any time served. I'm going to take in consideration 2023 CR 9387. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, so we can go off the record. Here's the thing. I understand that there are issues in everybody's life. Nobody has a perfect life. Everybody has some trauma in their life. But when you go forth in the world, you got to go forth and try to do the best that you can in life and try not to inflict trauma on other people. And sometimes that trauma is stealing somebody's property, right? When you take somebody's car, that's trauma on them, because guess what? They paid for that car. They probably struggled to pay the note, struggled to pay the insurance. And 9 times out of 10, when you finish paying off a vehicle, that's when you start having problems with it. But they work hard for that. That day when you were driving, the Eagle helicopters coming out and you're racing, trying to avoid the police, guess what? Everybody that you passed probably had to clutch their heart because, oh my gosh, I almost got hit, right? That's trauma for them. The garbage truck that you ended up parking in between to Brian, the garbage people who are working, they just trying to get their day in, pick up the garbage and go on their day. They probably had trauma from that. And then when you hopped out of the passenger vehicle and took off running, I'm sure there were other people probably with their children just enjoying their day. Oh my gosh, something's going on. So everybody experiences trauma in their life. It's just the way that you handle it. And I know that my sending you to prison, that's trauma for you, right? Because you want to be with your family. But you're going to have to go to prison, continue what you did at the jail. At the prison, you can actually get a college degree. And guess what? It's free. And I will tell you, all the attorneys here, unless they got a full scholarship, their degree was not free. And some of them are still paying on their loans. And guess how much those loans are? The equivalent of a mortgage. So there are good things for you to look forward to. So when you go to the prison and come out, remember this and remember that you are a habitual. So usually, depending on the offense, your minimum is 25 years in prison. All right. Good luck to you, okay?
Uh,
Yes. Yep, because the court, well, I'm not the person who took this plea. You understand? You need to speak up so the court reporter can hear.
Sorry, yes, ma'am.
All right. So according to the plea bargain agreement, the state is asking that your community supervision be for a term of 5 years. Did anyone want to speak to the length of community supervision, state,
Not to the state, we just feel it's appropriate, Your Honor.
defense?
Judge, I would just ask for it to be 4 years deferred, and I know a fine wasn't listed in there. I would just, well, I'm stepping ahead a step, but he works as a cook at Pluckers. So he doesn't make all that much money. on asking maybe if the fine can be probated or be relatively low.
Okay. And what is the court cost in this case, please? All right, Mr. Sanchez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Zachary Sanchez.
All right, so I've just been told by the clerk the court costs in this case. Will you be able to pay that over a period of time in installments?
Yes, ma'am.
All right, if you can't pay it, just let the court know. You understand?
Yes, ma'am.
All right, and then I have the MIC evaluation. Have everybody seen the mental health evaluation on this case?
I have, Your Honor.
Yes, Your
All
Honor.
right. Any input from either side?
No,
No.
Your Honor.
All right. So, Mr. Sanchez, it is saying here that you do need to be placed on the mental health caseload. Probation, based upon the nature of the offense, will mental health still accept him on their caseload?
We have employees on the SOMA unit that will assist him with these.
All right. So what I'll do then is I'll say the mental health sex offender unit. There's going to be 4 years deferred adjudication. Chapter 62 compliance. No contact with the complainant in the case. There should be regular reporting by Zoom or in person. There's to be regular UAs. Proof of employment within 30 days. There's to be no employment as a health care provider or with minors. There's a request for community service hours, but because of the nature of the offense, there's no community service hours available for you because no one has insurance to do that. You understand? There's to be no unsupervised contact with minors. Probation, is there anything else?
There are, the sex offender unit will take care of the field test, as a field visit.
Yes.
There's nothing else.
All right. Is there anything else you need from the court to be successful? If there's something else you need, now's the time to let me know.
No, it's fine. It's fine. I think you did something.
Nothing, Your Honor.
All right.
Thank the court.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Thank you. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand? All right, you all have victim impact?
Yeah, it's on the Zoom.
All right, and is it the Garcia?
Yes.
Okay. And I'll stop video. All right, Ms. Garcia? No. The video is just not shown. All right, Ms. Garcia, if you can unmute, please. All right, Ms. Garcia, Mr. Sanchez is here.
Okay,
And you may proceed with your victim impact.
okay, it's going to be my daughter, Sadie.
All right.
Go ahead. I'm holding. Okay. Zach, I don't know what to say. I could tell you that you ruined my life and how messed up I am. Or I could tell you I forgive you for what you did. I don't know how to feel. I'm angry. I'm angry because I didn't deserve what you did. You were supposed to be there to protect me. You were my family. Family doesn't do that. I needed you most when I was there. I thought I was safe, but I was wrong. Since that day, I've never been the same. I don't go out or wear shorts like I used to. I can't sleep and still have nightmares because of what you did. I can't stand when people touch me anymore, and I can't even let my 9-year-old brother touch me. You turned me into a person I never wanted to be. You turned me into someone who doesn't go to places, into someone who can't be alone in a crowd, into someone who can't stop shaking and who takes pills to be happy. I wish you could explain to me why you did what you did. You took my family away from me. My aunt doesn't want to look at me anymore, and my cousins don't believe or trust and can talk to me anymore. I kept it a secret for so long because I knew what my family would do. I understand that you are family, and I love you. I would never make something up like this. Why would I make something up like this? I knew as soon as I opened my mouth that my family would be gone and I would never be the same. You took everything from me, and yet I still forgive you. I forgive you for me to move on in life. I love you.
All right, thank you so much for coming in.
Thank you.
Thank you, Judge. May we be excused?
Yes, if he'll just remain and speak with the probation officer. All right, thank you. Thank you. All right, court is calling 2021 CR 2955, State of Texas versus Victor Alvarez Jr. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
John Robertson for Mr. Alvarez.
And are you Victor Alvarez?
Ma'am.
I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am. Yes, ma'am.
Are you the same Victor Alvarez Jr. who was placed on community supervision in 2021 CR 2955 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on July 15, 2021, for a term of 4 years. Is that you?
Yes, ma'am.
All right, state.
Your Honor, violated condition number 2, on or about the 12th day of December 2023 in Bear County, Texas, the defendant, Victor Alvarez Jr., did then and there admit illegally using a controlled substance, namely heroin, in violation of condition number 2.
How do you plead to that? True or not true?
True.
State?
Your Honor, the state waives and abandons the other.
Any
conditions.
objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you up to 4 years in the prison and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor, yes.
What are you all requesting?
Your Honor, the Victor was in drug court and had some challenges in drug court and was ultimately discharged in December of 23.
Mhm.
The probation department is recommending safety. He had previously been evaluated for SATF and DDRF, but was declined due to his physical condition. He has 2 prosthetic legs. From talking to Victor over the last couple of weeks, I know Victor, he admits he has a drug problem and he wants to continue to work on that. Victor would like to be considered for being put back into the drug court program and continuing to work with them. And I know he'd like to address the court about that.
All right, you'd like to address the court?
Yes, ma'am.
Can you raise your right hand? Do you solemnly swear or affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for a record.
Victor Alvarez Jr.
All right, what would you like to say?
I want to say that I messed up. I did my anger getting away, and I've been working a lot, real hard with drug court, trying to focus on my recovery. And before I went to jail, I talked to my counselor at Alpha, and I told her about getting into anger management classes and continuing with treatment there too. And I really want the opportunity to finish drug court, and I finally got the chance to get new prosthetics, and I'm in the process of getting new prosthetics before I came in here. If you give me a chance, I promise you that I will complete drug court, and if I mess up, you can sentence me to whatever amount is right.
All right. Probation, what is your recommendation?
Recommendation is to extend probation for a 1.5 years, and it's complete the safety followed by after.
All right, this is what the court will do. The court will deny the motion, alter and amend conditions to extend for 2 years, a referral to felony drug court. If felony drug court does not accept him back, then he's going to safety. Is there anything else?
Sorry.
Is there anything else you need from the court to be successful?
Do I have to go? Can you put me in anger management classes, or do they do that?
Oh, yeah, I'll add anger management classes. Thank you.
Thank you.
And also anger management classes. Thanks for letting us know that that's an issue, okay?
Yes, ma'am.
All right. If you need anything and you feel like it's not being addressed by your probation officer, you can always come back to the court. Do you understand? All right, we can go off the record. Here's the thing. Felony drug court is a good program, but they can't help you if you're not trying. And what do I mean by that? What I mean by that is throwing up your hands and say, well, I'm just going to use. Because I know in felony drug court, there's a lot of people that you can call. And I know over there, probation officers give you their cell number. You have the cell number to your counselor. So instead of breaking down and using the heroin and meth, you should have just picked up the phone. And you can pick up the phone with them and you can call them and say, hey, this is what's going on. And I'm about to use some heroin and meth. And you know what they do over there? Somebody will either say, come in, let us talk to you, or either they'll go to you or get a ride to you to bring you in to talk to your counselor. But if you don't do that, nobody can help you. You understand?
Yeah.
All right, good luck to you. Don't be the person that they're trying to identify on the side of the road or in a field somewhere and it's you. All right?
Yes, ma'am.
Okay, good luck to you.
Thank you, Judge.
You're welcome. All right, why were you late for court?
Oh, the traffic.
You have to plan for traffic.
Yes, ma'am.
Am I late for court? No.
Also, I was trying
And-
to have
So-
I was walking my elderly father. He doesn't walk that fast as well.
You need to plan for that because let me explain something to you. Am I late for court? No. And all the defense attorneys will tell me, oh, Judge, why are you rushing? You can be late for court. But I don't ask people to do things that I myself are not prepared to do. Your attorney doesn't have to be on time because guess what? If he's not on time, normally nobody's going to hold him in contempt or put him in jail. But if you're late, guess what?
Yes, Your Honor.
All right.
Yes, ma'am.
Okay, so what's happening with Mr. Ashb's case? We were here last time for discovery. Where are we on discovery?
Your Honor, I believe we have taken care of all the discovery issues in this case. I've been conferring with opposing counsel since the last court setting. They have provided me with a copy of the phone extraction, and we have made arrangements for me to review the TJJD file.
All right, and are you prepared to make an offer or was an offer tendered?
No, ma'am, there hasn't been an offer yet. We would appreciate a recess so we could make an offer to the defense judge.
All right, I'm going to recall you all for March 18th. I'm sorry, not March 18th. Yes, March 18th. And on March 18th, state you need to be prepared to make an offer.
Yes, ma'am.
All right, once you sign the reset form, you'll be excused. Make sure you're on time next time. Do you understand?
Yes, Your Honor. Thank you, Judge.
Oh, you're welcome. I keep forgetting it's 2024. Oh, gosh, it is.
Your Honor, I apologize. I forgot to address something. Would it be able to approach again?
Yes.
Okay.
Yes.
Your Honor, I apologize about that. Forgot to address Mr. Ashbaugh. We filed a motion to modify his bond conditions yesterday. We're just asking that he be allowed, he's on full GPS house arrest currently, that he be allowed to take his daughter to, is it school or daycare? School, in the mornings. His girlfriend who he lives with, the mother of the child, is currently enrolled in college and is not able to take her in the morning. It's placing a hardship on the family. We're just asking for a 1 hour window of time in the morning that he be allowed to take his daughter to school.
Just one moment. I think I have a motion here.
Also have a copy for the court in case it is not in the court's file.
Yes, I have it in the court's file, but I don't have an order attached.
Copy of the order, Your Honor.
State, are you going to have any objections to him dropping his daughter off at school? And
Yes, Your Honor, due to the nature of the charges, we are opposed to this motion. We'd request a hearing.
all right. So what I can do is I can forward it to Judge Nahara for a hearing. We're currently in a jury trial.
Yes, Your Honor.
So I'll let the clerk know and we'll see if maybe Judge Nahara can hear this today or when he can hear it. All right, is there anything else?
No, nothing further, Your Honor.
Okay.
Thank you.
You're welcome. All right, court is calling 2018 CR 0858, State of Texas versus Christopher Lamir. Can I have the parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
For the defendant.
And are you Christopher Lamir?
Yes, Your Honor.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Christopher Scott Lamir who was placed on deferred adjudication in 2018 CR 0858 for the offense of burglary of a habitation on May 13, 2019 for a term of 6 years? Is that you? State?
Your Honor, do you have the supplemental motion?
Let me see. Yes, and I'm also showing you the state's motion to supplement the motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney as well? Did you understand it?
Yes, Your Honor.
All right, and counsel, the court was just tendered the supplement Are you prepared to proceed?
We are prepared, Your Honor.
All right, state.
Violated condition number 33 on or about the 17th day of November 2023 in Bexar County, Texas. The defendant, Christopher Scott Lamir, did then and there fail to comply with the rules, regulations, or instructions of the res care facility, in that the defendant threatened other residents and destroyed property in violation of condition number 33.
How do you plead to that? True or not true?
Your Honor, we waive the other violations alleged in the motion to enter.
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 33, the court could find it true, grant the motion, sentence you up to 20 years in prison and up to a $10,000 fine?
Sure.
Knowing that, do you still wish to plead true to violation of condition 33? Court will find violation of condition number 33 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant on deferred adjudication, and we're asking that he attend the state ISF cognitive track program, Your Honor.
All right, is this going to even work? Because respite care was intensive and that didn't work.
I think the difference, Judge, from what I remember from the last hearing in September, when we had these questions for res care, are y'all gonna make sure he does the GPS? Are y'all gonna make sure he does these various things? And my recollection from that hearing is they're like, we'll do our best. That's not really up to us. I think state ISF is more structured. My understanding is that they are gonna make sure he's complying with the requirements of his probation, Judge.
And Judge, we've actually had issues with rest care. They've actually given him the wrong medication at times. In fact, this incident was a result of him being wrongly medicated. So I think his mother is also looking, once he gets out of IFSF, to get some other placements for him. And she's in the process of getting that done. I think he's got another year basically of probation left once he gets out.
Probation?
Yes.
Could y'all please whisper? Yes.
At this point, I think the recommendation would be for either state ISF or DDRF. He is not able to go back to the rest care facility.
And I know there have been issues with rest care because I don't know if he cognitively is able to be there. Because I understand them saying we can't make sure that his GPS is charged. That's something he should do. And I understand because of mental issues, he can't charge it. So, does anybody think he's going to be successful? That's my question.
I think I'd like to give him a shot, Judge. I understand it's.
I mean, he's not gonna survive in prison, Judge.
Well, I mean, sometimes prison is prison. It's not a happy place. But at some point, there is nothing else I can do. I mean, somebody write your legislator, write your congressman and tell them we need placements for people who maybe are low functioning, people who have mental health issues, because otherwise all I'm doing is rubber stamping saying, oh, let's try this. Let's try this. I'm going to try it. But Mr. Lamir, this is the last stop. There's nothing else for me to try with you. I don't think state ISF is going to work because respite care is more intensive than state ISF, but this is what everybody is telling me they think will work. I hope it will work.
You're gonna walk a straight line, Your Honor.
No, well, Mr. Lamir, I understand you're telling me that, but that's what you told me last time.
So last time they said they doubted that I would be able to do the AA sober support, and I've been doing better at that and sending it every day. They doubted that I would be able to do that, and I did it.
All right. I understand the issues and the limitations that we have here in Bexar County and elsewhere. I'm going to deny the motion, extend you for 1 year. Alternate amending conditions, we can do a referral to DDRF and also state ISF.
Your Honor, I need one.
Which one do you think is best probation, DDRF or state ISF?
DDRF,
All right.
I think it's better.
All right, so we're gonna alternate amend conditions to include DDRF. And hopefully they can address the issues that you have. You understand?
Sure.
All right, do you have any questions about anything?
Does that mean I would be getting off probation in May of 2026?
Whatever the extension is for the year, that will be 2026.
So I had contacted my probation officer and I called her and twice, 2 or 3 times and she didn't answer. And I had left her voicemail like 2 weeks before the incident occurred, trying to tell her I was having a medication issue and she never called me back or answered her phone. I wondered if maybe I could get a different probation officer.
All right, so let's do this first. I'm gonna make a notation of that in your file, and I have made a notation of that. We're gonna see about placing you at DDRF. And hopefully they will make sure that you have the right medications, because I'm not a medical doctor. I can't put you on specific medications. And if there's an issue with DDRF, just let us know, okay?
All right,
All right, thank you.
good luck.
All right, court is calling 2023 CR 9693, State of Texas versus Sergio Rodriguez Serta. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor. Tom Nisbet on behalf of the defendant.
And are you Mr. Serta?
See.
Yes.
All right, and we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes, Your Honor.
All right, you can lower your hand and state your name for the record.
Jacqueline Payan.
All right, Mr. Serta,
See.
everything that I'm going to go over with you are in English. Were those documents explained to you in Spanish?
See.
Yes.
And did you understand all the documents?
See.
Yes.
Counsel, have you received all the discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Serta, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
See.
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Serta, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
See.
Yes.
Did you understand you're charged with the offense of driving while intoxicated, third or more? Normally, that's a third-degree felony with a range of punishment anywhere from 2 to 10 years in prison and up to a $10,000 fine. In this case, if the state is able to prove up the repeat offender enhancement allegation, your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
See.
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
See.
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
See.
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
See.
Yes.
Counsel, has your client been able to provide you any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Serta, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
See.
Yes.
Are you a U.S. citizen?
No.
No.
Counsel, have you provided your client with information about his immigration immigration status and the impact this plea will have on his immigration status?
Very much so, Judge. He has retained Roland Gutierrez's firm. He has an immigration lawyer there, Garcia. They have taken marital steps and positioned themselves for all the immigration consequences of the plea here today.
All right, Mr. Serta. Were you advised of the consequences of pleading no contest or guilty in the application of federal immigration law?
No,
No,
no contest.
No, I want you to listen to my question. Did you speak with an immigration attorney about your criminal case?
see,
Yes.
Did that immigration attorney discuss with you the impact this plea would have on your immigration status?
see,
Yes.
Did that conversation include the fact that you may be deported, denied naturalization, and not allowed to re-enter the United States?
see,
Yes.
Do you understand the impact a plea in this case will have on your immigration status?
see,
Yes.
And have you retained an immigration attorney to discuss with you the impact a plea in this case will have on your immigration status?
see,
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
see,
Yes.
According to the plea, you're to agree that you've been previously convicted of a felony, that punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. There are no applications. There's restitution to Robert Ortega. And if you do not show up for sentencing, your plea in this case will stand. If the court finds there is sufficient evidence to find you guilty, that will stand, and you will be subject to the full range of punishment, which is up to 20 years in the prison. Did you understand that to be the plea?
see,
Yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
okay,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And to the enhancement paragraph, how do you plead? True or not true?
Yeah.
How do you plead? True or not true to the
Yeah.
enhancement paragraph?
True.
State any evidence to support the defendant's plea?
Your Honor, I offer State's Exhibit 1 and the attachments.
No objection.
Mr. Serta, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
see,
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. So how much time are you all asking for?
Judge, we would ask for a month if possible. His family is here, his wife, all his children, extended family members, they come to every court setting. He is on a leg monitor. the entire time he's been on bond. You have had no issues through the pretrial supervision services. We would ask for a month.
All right, Mr. Serta, I'm calling you back for a sentence. You can either come back on February 12th or February 20th. Court is calling 2021 CR 1907, State of Texas versus Vanessa Rosado. Could I have parties announced for the record for the state?
Your Honor.
For the defense?
Monica Corolla?
Are you Miss Rosado?
Yes, ma'am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review this document
Yes, ma'am.
with your attorney? Did you understand it?
Yes, ma'am.
All right. Are you the same Vanessa Rosado who was placed on deferred adjudication in 2021 CR 1907 for the offense of theft of aluminum, bronze, copper, brass on March 1st, 2022 for a period of 2 years? Is that you? Oh, no problem. State?
I'm sorry, just. give me
That's
a second,
okay,
Robert.
sure.
Which one is she going? This one. Violated condition number 2, on or about the 31st day of October 2022 in Bear County, Texas. The defendant Vanessa Rosado did then and there legally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
And Your Honor, we'll waive the remaining violated conditions.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That is to deny the motion to adjudicate guilt, continue on her deferred, extend for 18 months, refer to felony drug court, also have GPS for 3 months, also weekly UAs, also parenting classes, also report 2 times a month, or in person or in Zoom, Your Honor, and that would be the agreement.
All right. Are you asking the court to follow that agreement?
I am, Your Honor.
Are you asking the court to follow that agreement? The fact that the state is asking so much of you and probation is asking so much of you tells me you've done nothing. So I'm going to give you a choice because I don't know if you're going to be successful or not, but it appears that you have done nothing. And I'm looking at the docket sheet. And at the docket sheet, at first, this was supposed to be a pretrial diversion. And all you had to do was pay $547 for that to be done. And then we've had a motion that has been filed before and that has been withdrawn. And now we're back here. So here's your choice. I can extend you for 2 years. I'm not going to extend you for 18 months. I'll extend you for 2 years. Or either I'll sentence you to the state jail facility for 18 months. You'll complete it. You'll be done. You can do what you want to do with your life. Otherwise, I'm going to continue you and I'm going to follow these recommendations.
And my choices, what was the previous?
18 months in the state jail facility, or either you're going to be extended for 2 years. There'll be a referral to felony drug court. You're going to remain in custody till felony drug court accepts you. If felony drug court does not accept you, you're going to safety. So which would you prefer?
The second, the 2 year, 2 years instead of the 18 months.
Okay. All right, the court will deny the motion, alternate amend conditions to include a 2-year extension, a referral to felony drug court. If not accepted, then safety. And this is all to be done in custody. Parenting classes. There's to be no unsupervised contact with minors. There is to be partial GPS for employment only. no employment as a home healthcare provider or with minors. The UA hotline until further notice. And field visits one time per month for 3 months. And then at probation's discretion. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
Your Honor, if I could just provide the court with a little bit of information with regard to the parenting class
Yes.
that's been added as a condition. Ms. Rosado has a 2-year-old grandchild in the house where she lives. She has a 24-year-old son who suffered from significant mental health issues last year, which is how Ms. Rosado ended up caring for his child. He has gotten the mental health assistance that he needs. He's on medications and he's actually gainfully employed and living outside of Ms. Rosado's home. However, the grandchild still does reside with her and she is charged with taking care of him. This is something that she volunteered to do as a grandparent. It was her responsibility and our heart to do that. The unsupervised visitation that the court just imposed as a condition of that probation. In light of those circumstances, I was wondering if you'd reconsider the unsupervised visits that you imposed. It has nothing to do with any dangerous conditions in her home that she has created. I do understand she has a positive or an admission to using methamphetamine in 2022. However, that was prior to her having a grandchild. So I don't know if the court would reconsider unsupervised
Well, let me
visitation.
ask this. Has she been reporting? I know that's an allegation in the motion, but there was no plea of that. So has she been reporting?
Correct. That was, she has not been reporting, which is why we suggested a GPS for 90 days to get her back on.
Has she
track.
done any, since she hasn't been reporting, that means that she hasn't done any UAs. Am I right in assuming that?
I believe that would be a safe assumption.
All right. So I don't know if she's using meth or not, but I do know if you're using meth, you shouldn't be babysitting anybody's grandchild,
True, I agree.
right?
And
All right. So that's where we are. There's to be no unsupervised contact. And I don't know if Child Protective Services are involved or not. They probably should be. If the option is your son has mental health issues, so he should not be alone with the 2-year-old. And then you're using meth. That's not a good combination for either parent for a child if your son is not on his medications.
my son, he's taking Zoloft, he's been taking Zoloft for almost half a year now.
All right. So then that's where we are.
Yes, Judge.
All right. Thank you.
Thank you, Your Honor.
All right, if you need anything, you feel as though probation is not addressing the issue, you can always come back to the court. Do you understand? All right, thank you. Ray Espinosa. All right. So where are we on this?
Judge, we were here on January the 18th, and ECL entered pleas of true to some of the allegations in the
Yes, 1, 2, 5.
and some were waived.
Yes. So the only one he pled true to is 1, 2, and 5.
Right. And we were asking the court to place them in a state ISF. And I believe there was some notation by probation that they would like to amend and extend and place them in the state ISF. However, the court had a question about these other waived allegations in the MTR about what the status of those were. And we
Yes.
wanted the status update on that. That's why I believe we're here.
Yes. So what is the status?
Your Honor, so we're asking for the 3 years on the MTR, 3 years in the prison. We are not ready on the drug cases yet. The labs have not come back on those cases yet. We would like to proceed on those when we do get the labs back. Because it is a 4 to 200 possession with intent.
So when are the labs coming back?
I can check with the intake attorney on that, Judge.
Because what I have in my notes is that he pled true. And the state was to obtain the labs at the end of the month. And then the court would make a decision.
And one of the things I think you heard, Your Honor, is that because there's pending cases, he's not presently eligible for the state ISF. So we're kind of in a catch-22.
So this is what I'm going to do. I'm going to recall this. And we'll recall it for February 29th. Will you have the labs by then?
I am not sure, Judge. I'm gonna check with the lab. I'm gonna try and get those expedited, but we're asking for time here, Judge, and
Okay.
these are more serious charges that are pending than the ones that he's already pled on.
I understand the court's position, but if I were to sentence him to time, he's just gonna be sitting at the jail because we have these other pending cases. And I really don't know, defense, I believe you want him to be continued in ISF. I can't intelligently and knowingly make a decision on whether he should be extended, whether he should go to prison until I know what the other cases are. I don't even know, the amount of drugs that's being alleged in the other case, if it's intent to deliver, or is it regular possession, what the drug is. So once I have that information, I'll be able to make a decision on the motion to revoke. I mean, because not knowing anything, I could say, oh, 3 years.
Right.
Then we'll wait for the other cases. But I don't think anyone wants me to make a decision without having information.
And he's been in custody now over 100 days, so.
All right, so we'll come back on February 29th. Hopefully we'll have the labs. If for some reason, the request for the labs is going to be extended, if they say they're backlogged and it'll be 6 months, then of course I'll have to make a decision with the information I have.
Yes, ma'am. I'll send an email right now.
All right, is there anything else?
No, ma'am.
All right, so we'll be back on February 29th. All right.
Judge, I've got another case where,
Oh, just 1 second. You can have a seat. I don't know if that means so that you all are protected or if it's for everybody else. So,
You only need to be protected from me, Jen.
all right, court is calling 2023 CR 11320, 11321, 11322, 2023 CR 4301 and 4302. That party is announced for the record for the state. Defense,
Meredith Chacon for Mr. Barnes, Your Honor.
and are you Mr. Barnes? Counsel, and each of the cause numbers, have you received all of the discovery and did you review it with your client?
Yes.
And each of the cause numbers, the court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Barnes, in each of the cause numbers, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand them?
No.
State, are you proceeding on the indictment as presented and cause number ending in 11320? That has an enhancement allegation.
11320, yes, Your Honor, we're proceeding with a repeater that would make that a state jail, a repeater, which is a third degree.
And I explained that to my client. He'll be pleading true to the repeater on that particular charge.
All right, and in cause number 2023 CR 11321, are you proceeding on the indictment as presented in that cause number?
Your Honor, we're proceeding on count 1 with the repeater, waiving count 2.
Any objection?
That's the second degree, correct, Jason?
It makes it a second.
Yes, that is correct, Your Honor. He is going to plead true on that repeater.
And cause number ended in 11322, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving enhancement, but we are proceeding on count 1, 2, and 3. And that keeps that at a first degree count.
And I've gone over that with my client. That is working.
And then in the cause number ended in 4301, are you proceeding on the indictment as presented? And then in cause number ended in 4302, are you proceeding on the indictment as presented? Mr. Barnes, in each of the cause numbers, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions?
Yes, ma'am.
Did you understand it? Did you sign it in all the appropriate places? Did you understand in the cause number ended in 4302? The offense charge is unauthorized use of vehicle. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. And the cause number ending in 11320. It's an unauthorized use with a repeater. That puts your range of punishment at anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 11321. It's a felon in possession of a weapon with a repeater count. The range of punishment for that offense with the repeat enhancement allegation is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And the cause number ending in 11322. That is an aggravated assault against a public servant. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. And the cause number ending in 4301, that's an evading arrest detention with vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And all of the cause numbers, if you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And all of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your
Mr. Barnes, and all of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
And the cause number ending in 4302, punishment is to be assessed at 2 years. All of the cases will be running concurrent. State is taken in consideration 2024 CR 0918, night mag number 733-464 and 460. And the cause number ending in 4301, punishment is to be assessed at 10 years in the prison. All of the cases will run concurrent. The same cause numbers will be taken in consideration as in 4302. And the cause number ending in 11322. State is proceeding on counts 1, 2, and 3. Punishment is to be assessed at 12 years in the prison. There's an affirmative finding of deadly weapon. All of the cause numbers will run concurrent. The same cause numbers will be taken in consideration as in 4302. And the cause number ending in 11321. State is proceeding on count 1. Punishment is to be assessed at 12 years in the prison. Cause numbers are running concurrently. The same numbers are being taken in consideration as in 4302. And the cause number ending in 11320. State is requesting your punishment be assessed at 10 years. You agree that you've been previously convicted before of a felony. The cause numbers will all run concurrent. The same cause numbers will be taken in consideration as in 4302. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 11320, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And how do you plead to the enhancements? True or not true?
True.
And cause number ending in 11321, how do you plead to count 1?
Guilty.
And how do you plead to the enhancement?
True.
And cause number ending in 11322, how do you plead to count 1,
Guilty.
count 2,
Guilty.
count 3?
Guilty.
And in the cause number ending in 4301, how do you plead?
Guilty.
And in the cause number ending in 4302, how do you plead? State any evidence to support the defendant's guilty pleas?
No objection, Your Honor, and I did go over all of the attachments with my client.
All right. Mr. Barnes, did you review the documents entitled waiving consent to stipulations and testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find in each cause number that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And cause number ending in 11320, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty, and the court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your
Anything you wish to say on behalf of your client?
Honor, I believe he's taken responsibility. He's pled guilty to everything, and so I would hope that the court would follow the plea bargain and allow us to move these cases today.
All right, then in the cause number ending in 11320, the court is finding you guilty. Enhancements true. Court will sentence you to 10 years in the prison. Give you credit for any time served. This will run concurrent with 2023 CR 11321, 2023 CR 4301, 2023 CR 11322, and 2023 CR 4302. Take in consideration NIMAG numbers 733-464, 733-460, and 2024 CR 0918. Is there anything with regards to sentencing in that cause? Anything else?
No.
And that cause number, I'm gonna show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? Next, we'll proceed to cause number ending in 11321. Right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Jason. Are you ready to proceed with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, I've already said it.
All right, and that cause number, as previously stated, the court is finding you guilty. Court is finding that enhancement true. Court will sentence you to 12 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 11322, 4301, 11320, 4302. Take in consideration NIMAG number 733-464, 733-460, 2024 CR 0918. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, You do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Next, we'll proceed in the cause number ending in 11322. Thank you all for the highlights. It makes it so much easier to read. All right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of count 1, count 2, and count 3. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No.
Then the court will follow your agreement, sentence you to 12 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with the following cause numbers: 2023 CR 11321, 4301, 11320, 4302. Take in consideration NIMAG number 733464, 733460, and 2024 CR 0918. Anything else with regards to sentencing in that cause number?
No.
Did you review the document entitled Trial Court Certification with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Next, we're going to proceed with cause number 4301. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No.
Court will follow your agreement. The court will sentence you to 10 years in the prison, give you credit for any time served. This will run concurrent with 2023 CR 11321, 11322, 11320, 4302. Take in consideration NIMAG numbers 733464, 460, and 2024 CR 0918. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, you're going to proceed in the cause number ending in 4302. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Court will sentence you to 2 years in the state jail facility, give you credit for any time served. This will run concurrent with 2023 CR 11321, 4301, 11320, 11322, NIMAG number 733464, 460, and 2024 CR 0918. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Oh, I already gave it. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, and because all the cases are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
41, ma'am.
All right, at this point in time, really, there is nothing I can say to you, right?
No, this broke me right here.
All
This is
right.
my first aggravated time, and I was hoping to get something lesser, but I mean, I'm gonna cop up to what I'm a man before anything, you know what I mean?
Yeah.
I'm not like, really like,
So here's,
this really broke me, you know what I mean? Like, right at night time, and I got my mom, my brother, you know what I mean? So it's not, I'm too old for this, I'm too smart. I build houses, I build restaurants.
so you're gonna have to do better, because
So
otherwise,
I have no reason.
all right,
I shouldn't be in this trouble, you know what I mean?
because here's the thing, at the end of the day, if you don't change your ways, you're gonna end up being in the prison for the rest of your life. You're gonna look up.
I look around me when I'm in jail and I see 60-year-olds, 65-year-olds, like, man, I don't wanna be like that. I'm too
Well,
smart.
here's the thing, don't be that person then.
I'm not. Once I'm,
Did you ever watch, what is it called? The Shawshank Redemption?
yeah.
Did you see, there's a scene in there where this old guy has been in prison for so long, he doesn't want to go on parole.
Yeah.
They sit him on parole
And
and he ends up killing himself.
Yeah, kill himself because that's his life. That's what he knows.
Don't be that person.
I'm
All right, good luck to you, okay?
Thank you, Judge.
Thank you. Oh, could I see this one?